All right, all this personnel committee meeting fixed at 5 o'clock. Do we have any, I don't guess we have any director requests because we're all here. Public comment.
Nothing that's not on the agenda for item 3.
Those move to item 4. You in discussion of proposed updates to district personnel policy.
So we took our personnel policy and sent it to Liebert Cassidy Whitmore, our HR resource attorneys, and said, we have a couple of areas where we have some questions and we want you to take a look at it and make sure that it's up to date as it relates to any appropriate laws and standards that we have to comply with. And so everything that's in here is basically their comments. This red line is their red line. And so
clarifying terms that were not previously clarified.
no, and adding some things. I mean, there's some substantial changes to here. But this is their red lines. All we did is said, hey, we have some questions on this area and we have some questions in this area. Can you go through and come up with red line changes to make sure that it's written correctly? And so that's what you have before you is the red line markup from Liebert Cassidy. We kind of had some global areas that we had some questions about, and we had some discussions back and forth. Our questions were about laws we have to comply with, overtime rules, compensation time, comp time, and then some other little tidbits. The biggest sort of groupings of things are kind of their comments on our rules, our questions about overtime, our questions about comp time, and then some minor tidbits. So we can go through them however you want, page by page, and kind of talk through them, or however you want us to sort of proceed.
I think we should go through and talk through them.
So the first section is section 2-10, fringe benefits. And fringe benefits used to mean boot allowance, some sort of minor sort of supplementary things that we paid for. And over the years with some legal determinations, fringe benefit has basically come to mean a whole list of things that are other than salary. So everything is sort of a fringe benefit. Dental insurance, health insurance, the list here, all of those things are now considered fringe benefits. So this section defines fringe benefits as what they specifically mean in the context of, some of the recent sorts of cases that have come out of various legal actions. We can go through that sentence, but this is what Liebert Cassidy wrote and said, here's what fringe benefits means.
Because I'm glad we're starting with that one, because it doesn't appear to me be either correct or complete. Second sentence, examples of fringe benefits that I would say that may be offered by the district, because listing all of these include but not limited to. Does everyone in the district get a benefit of cash in lieu of benefits? Does everyone get a car allowance?
Or we don't. And so you want to include,
Say that may be offered.
okay, so we'll add that in there.
Because it's going to be different for different employees, I think.
Okay.
And then you mentioned a boot allowance.
So
The boot allowance is a reimbursement, so it's not part of the fringe benefit list.
but it used to be,
I see.
that's what it used to be. It used to be a fringe benefit Was,
It's a fringe benefit that you get the reimbursement.
but that's what it used to be. Now it's this more exhaustive list. And we can add the may be offered because in some cases we don't offer. But this is the language that they came up with specifically.
Okay.
So we can add that.
And on-paid status, that's defined somewhere else too, if I recall. But that means if you're on a leave without pay,
Correct.
then you're not on paid status, but the rest of the time you are.
You are.
Okay. You're on vacation, you're on paid
You're
status.
on jury duty, you're on paid status. So then the next couple of pages, there's, we deleted overtime out of this section and definitions, and there's a big exhaustive list in chapter 15. So it didn't mean we're deleting overtime, it just meant we moved it. And then there's renumbering, to account for what's been deleted.
2.19 on page 5. I hadn't seen 32 before. I thought 30 was the standard. But
Actually,
that may
40.
be a change in tax law or something.
It's actually 40. Lieber Cassidy, after some discussions, we defined it as 32 for our purposes.
Well, this is part-time. Part-time would, I guess some places they say anything less than 40. But, in France, they're looking for 32 hours and 40 hours pay. But the standard that I had seen in various companies was anything under 30 was. But
It's actually anything under 40 planned is less than, if you're scheduled less than 40, you're part-time. But we've defined it as 32. We don't have anybody that's on this determination now. But we need to make sure we at least have a section in our code that calls out what it is, the definition. If we ever got to the position where we wanted to have or needed a part-time employee for some purpose that would be defined later, this would be the section that we would use to determine it.
And you came up with 32 as better than
For less than,
less than 40.
so then there's some page 7, 2-30. We deleted standby duty, that got moved to a later section.
Yeah, I didn't see where it went.
And then in chapter 4, on page 11, it once again, all been moved to section 15.
Yeah, all the overtime stuff, right.
And then on page 14, chapter 6/5. So one of the things that came up in their review is that we have a program where if you retire from the district after 10 years, that you are eligible for post-employment benefits to get up to whatever the cafeteria plan is for retirees for medical benefit. However, there's nothing in our old code, old language, that says what happens if you're less than 10. It just said more than 10. And in Lieber Cassidy's opinion, to make a determination for something that is over 10 and leave it undefined less than 10, they felt that there was an unequal benefit sort of discussion there. And so they've included that if it's less than 10, you'll be eligible for the PEMCA minimum, which is $150 a month. And so it's not that somebody get nothing and somebody got something. Everybody got something, but then there was a determination. If it was greater than 10, you had one benefit. If you had less than 10, you got a different benefit. But at least if you retired from the district, you got a benefit.
I don't see that in here.
It's page 14, 6.5.
Well, I see 6.5. I'm glad to hear the differentiation between 10 and less than 10. But this doesn't say anything about 10 or less than 10. This is pulled it right off the web
Oh.
today. And I was also confused by the cafeteria plan minus the PEMCA statutory minimum. So part of the cafeteria plan that is available for each employee is actually money that is not liquidated by the employee by buying an insurance policy, whatever, but it's paid to some state agency instead. That's this PEMCA statutory minimum monthly employer contribution.
But it's used for the purchase of health insurance coverage for themselves and qualified dependents. So you don't get the 150 as cash after you retire.
Okay.
You get it contributed on your behalf if you purchase if you get medical coverage through the district. Someone retires after 5 years and they want to avail themselves to CalPERS health plans. We will pay the PEMCA minimum towards them purchasing that healthcare plan. They will be
What if
responsible.
they're active in the district now?
If they're active now, they get the full cafeteria plan to purchase their medical plan. This is
Solely for retirees.
solely for retirees.
It doesn't say that in this paragraph either. There's
Um,
nothing about 10 years in this paragraph, and there's nothing about retirees in this paragraph. That's what left me confused. I wasn't clear on to whom does this paragraph 6.5 apply and to what extent?
It-
That down here in the,
No, it applies, it does, it actually says on page 15, and
Yeah.
it's a general health insurance statement. Our resolution that we pass every year in July that we
Right,
review for the
yeah.
cafeteria, that's what's referenced there, so we don't have to change our personnel policy every time we change that. So it references the salary and benefit schedule, and so that's directly tied to the resolution that you guys approve around July every
Okay.
year.
okay,
So in here, and then later in there, it says a cafeteria plan is available to current employees and retirees, which is true. That cafeteria plan is available to retirees without the cashback feature. If you retire for the district with 10 years, you have that full amount available to you. If you have less than 10 years, we are required to contribute the minimum. So CalPERS will bill us for 150 and then they'll pay the rest. Same as if anybody went over their cafeteria amount that was a 10-year retiree.
okay.
I mean,
Where
we
does
can
it say that?
salary and benefit schedule spells it out further, the reference to the salary and benefit schedule.
Okay.
But we can definitely put extra stuff in here from there. The
No,
only
I
hard part
just-
is anytime you change that, you have to change this paragraph.
No, I don't want to go to that trouble. So the reference to as established by the salary and benefits schedule, then has the 10 years, less than 10 years
Yes.
stuff in it. All right.
But their opinion was we couldn't have some benefit over 10 and zero less than 10. And so this is why this minimum was set up.
Why couldn't we have that?
They say legally that it's not appropriate to have under PEMCA to have, you're providing a benefit to someone and purely on 10 years service, you're saying it's zero. You can have a different amount, but you can't have zero. Now, if someone retires and chooses to not use CalPERS medical plans, they go to Blue Cross or Kaiser or something else. They don't get a cash dollar from us. They only get this PEMCA minimum if they funnel through us and get their medical plan
They
through.
get CalPERS insurance. But you don't take away the PIMCA statutory minimum. Everyone.
Well, the cafeteria plan exceeds the minimum, so the 10-year people do get a greater benefit, but a retiree with less than 10 years can't have zero benefit.
Okay, I understand that part. And my ignorance or something, processing today, it says the district provides this plan established by the salary and benefits schedule minus the statutory minimum. And it says that's for all active employees and retirees. So you're not actually doing a minus the minimum statutory
No,
contribution.
check on that language, because no, it is not a minus statutory
No.
contribution.
It sounds to me like that sentence there applies to everyone. And
So we'll check on that sentence.
I think you're correct.
so maybe it just says as modified by the salary and benefits schedule or something.
Yeah.
That's what was not clear to me, as well as what the statutory minimum thing was. Okay.
Yeah, to help me, I think I could see just a hypothetical example of happens to a 10-year retiree.
Well, I can tell you. So if someone retires from the district after 10 years, up until the point they're 65, they get whatever medical plan they want up to the amount of the cafeteria plan that we provide.
I
So
don't like that at all. And people's full medical, guy comes in at age 20, starts to work, age 30, decides to go somewhere else, calls it a retirement.
you have to retire. You have to retire from here.
Be an eligible retiree.
You have to go in full retirement under the IRS rules. You don't get to leave here at 30 with 10 years experience and get medical coverage from 30 to 50 while you're working somewhere else.
I didn't understand.
You only get it if you're actually fully retired.
So the definition of being retired, there's some IRS definition.
There's an IRS definition where you can only work 960 hours a year. You're eligible. You have to file for Social Security at 62, all of those things. So in practical terms, what happens here is someone works till they're 60 or 62 or 64. Up until 65, they're covered under our cafeteria plan amounts. At 65, you're required to file for Medicare, and Medicare becomes primary. And so then the amount that is supplemental under the medical plan is much lower because you have to go on Medicare first. And so the reality is we have some 62, 63-year-old people who are a couple because their kids are gone and no longer eligible dependents. And so they may be anywhere from $1,200 to $1,800 a month for medical coverage, typical. They're under the cafeteria plan amount. At 65, they file for Medicare. That is primary, and then our insurance becomes secondary, and the medical coverage drops down to $600 or $700 for that couple. Now, the other thing about this OPEB plan is all of those costs are covered by our trust fund. We have about $6.5 million in a trust fund for OPEB, and our cost actuarial says that for all our current employees and all our current retirees, the liability is somewhere in the neighborhood of $2.5 or $3 million. So we have more than enough money in our OPEB to never cost the district a dollar for any retiree medical coverage whatsoever for their entire life. So
So what's the earliest somebody could retire from the great, having worked 10 years? What's the youngest age they could?
well, you can retire under CalPERS at 55, under the classic, under new younger people, their PEPRA, which is a new act, says they can retire at 62. So
Later.
So it's later. So for there's a few of us, I'm included. I'm 57. I have my time in PERS. I'm classic. I could retire at 55. I'm not going to retire anytime soon. So I have my 10 years at the district. I could retire now and go on that medical coverage to 65, and then at 65 go primary Medicare. But there's only a couple of us that are in that category. Most of the people that have 10 years are my age, or and there's only a couple of us that even meet that criteria. Most of the younger people are PEPRA, and so they won't be able to retire till 62.
All right, that helps me. And what about the 650? Is that the same? They don't get that
Will
too?
not get that back.
Cafeteria plan becomes like a Medicare supplement?
Correct.
So it pays the other 20% that Medicare doesn't pay.
You walk in with two cards. Medicare is primary, CalPERS, whatever program, whatever plan you're under. I'm under, your Part C. Yeah. So most of our retirees are Medicare, if they're in 65 or older, they're in Medicare primary, CalPERS medical secondary, and most of those premiums are $600 or $700 a month. And we pay that bill to CalPERS. CalPERS bills us for X employees that are retired. They bill us for it. And then we go to our trust fund and say, here's the bill we got from CalPERS to pull out of the trust fund to backfill our general fund. So we pay the bill and then the trust fund pays us back. It's a $0 sort of effect.
And just a wrinkle in it, maybe I don't want to go down. If that retiree is married, has dependents, he turns 65, he goes to Medicare. What happens if his wife's still 62? Does she still get coverage from the district?
No.
It's just for the,
It's the whole account transference to Medicare plus the backup.
that's different than what happened with my family. My wife stayed on it for 3 years until she became 65. That's not how it works here.
So then going on, there's a couple of references under page 16, 6.6, 6.7, 6.8. Premiums not paid under unpaid status. And we jump ahead to 22. There's some notes about rest periods that are statutory required. And then on page 23, there's a remote policy discussion, and then a whole section on lactation.
These sound like things that are existing but unofficial policies. Now they're being documented.
Yes.
It sounded like pretty standard stuff.
And that's what we asked them. We said, here, take our whole policy and go in and edit it. There's a statement on page 28 about length of vacation.
27 had accrual,
Right.
pretty good, 3.5 years. I never got to accrue that much.
And that's not a change. That was actually a typo in the previous version that we're correcting.
Oh, that's right, changed from 2.5 to 3.5.
Kind of going backwards, but under 8.4, employees on page 22, employees may not work through meal or rest periods. So if you're in the middle of a spill or something, too bad, you just shut down, let it go until you finish your meal.
We're required by, governing state law to respond to the spill. What that means is it's then upon sort of our management of that spill to see if we can cut that person loose and have their rest period.
More people. I can see where that could be an issue. If we got a limit of staff on a holiday.
The next section is on page 30. We deleted comp time and moved that.
28 also, vacation request.
Oh, right.
Weird.
Vacation request longer than 2 weeks.
Designated person,
That's new. That's
sounds like a very new law.
it is brand new.
Name any person at all as your designated person.
Yes.
Somebody that's perceived to be family or a close connection that doesn't meet like the blood relative definition or the immediate family definition.
Bereavement is a whole new rewrite.
Bereavement thing looked very caring to me.
Changed from 3 days to 5 days this year and some other legal
By
language.
consecutive days necessarily. either,
Correct.
so.
Then there's a whole section of pages where there's a lot of little things. Leave without pay. Whole rewrite on
As a child.
whole rewrite on FMLA leave. What it is, definitions, child, family member, parent, designated person.
A grandparent. Okay, so grandparent does not include spouses. Parent.
Correct. It's the employee's parent.
The plain language is there. It just
Do allow for a parent-in-law, so that's kind of interesting.
That's where your designated person comes in. You get to define your own significant connection that's not listed.
We can change that. Grandparents-in-law, we could add that.
Well,
Can't be changed.
This is right out of FMLA law. And so this isn't sort of district discretion. This is federal law. And so by adopting these changes, we're basically saying, here's what not only is the federal written law mean, but here's the legal cases that have provided further definition to
We
it.
can do things over and above, the ones we're not violating law. If we wanted to, I'm just saying if we want.
On some things I would have a discussion. On other things, I would say there's a lot of very stringent case law when it comes to some of these, and I wouldn't recommend we start.
Into that, yeah. It is kind of odd, though.
on page 37, healthcare provider. Are there other that include dentists? They're not MDs, they're not DOs.
I think this is a legal definition of healthcare provider. And this pertains specifically to a medical provider, not a dental provider. We can ask though, and see if that. Mhm.
I don't know,
Well,
I've had a lot of medical people in my family, so I know you have podiatrists and you have other things, and I'm not sure that any of those people are DOs or MDs.
that's on the next page, top of 38.
Oh, it is.
Podiatrist, dentist, psychologist, optometrist, chiropractors.
You took out the number 1, but you've got a number 2 on page 38.
That's a format.
Yeah.
So that's a format.
Yeah.
Okay, clinicals, yeah, optometrists, all right, yeah. Yeah.
So we continue on page 38, 39, 40. All of these are legal definitions. 41, 42.
on 39, 9-12, 9.12.4, that 12 months in there again. Should we have a different, should we say something in days or?
That's their, the log, most of the
That's a
Of law.
legislative language.
legislative language, not days. Okay, this goes all the way to 45. They've deleted some of the things in terms of replacements. There's a change on page 47 or an addition about just misuse of leave. Then we get to page 57, chapter 50.
That thing there also with 9 and 13. Too much.
Got it.
So then we get to chapter 15, which is overtime. So what we operated under overtime was the federal standard, which is anything over 40 hours in a week is overtime. And it was working hours. And so what we wanted to do was we wanted to pragmatically look at how our employees worked and say there are other situations where we believe overtime should kick in. First, anything over 8 in a day should be overtime, and anything over 12 should be double time standard. The second part was we had situations where there would be district determined times that officially were non-working time. So this year we had 4th of July was on a Tuesday. So somebody worked Monday, was off on Tuesday, worked Wednesday, Thursday, Friday. Technically, by the time Friday at 5 o'clock occurred, they only had 32 hours of working time under the federal standard of 40-hour overtime. We have employees from time to time that are scheduled to work on weekends.
Somebody was there on July 4th.
Well, not just July 4th, but like on Saturday or Sunday is where our real problem was coming in. It's because they're scheduled. That wasn't like a call out or an emergency that's covered under one path. They were scheduled to work Saturday or Sunday because under our permit, we have to go in and do some minimum tasks at the treatment plant on weekends. We can't just do it completely remotely. It's not a full work day, but there are actual obligations that they have to be there for. So now they show up Saturday morning for working on Saturday, and it's not overtime because Tuesday was a holiday and that's non-working time. So pragmatically, what we wanted to do is say, if there was time during a week or a pay period that was district determined non-working, holidays, certain other parameters, we're gonna count those as
Counts against the.
still counts against the 40. Because what we started to have was employees are like, look, if I take 2 hours off to go to the doctor, and then I go on overtime I do it in this week, or my child gets sick, I have to take, half day off to pick them up from school. Now that's non-working time. And now when I show up on Saturday, I don't get overtime. I just don't think it's rational. I think if we're dictating their schedule, we shouldn't penalize them because they take their daughter to, or spouse or anybody to the doctor, or there's a holiday that we determined they weren't getting credit for it as a working day. So what we tried to do here was say the 40 hours applies, anything over 8 in a day applies, and anything during the pay period that's a district
Corrected.
directed sort of time, it still counts towards your 40. If you take unpaid leave or something, well, that doesn't count. But if you're on a holiday or taking sick time to take care of a spouse or a child or something, you shouldn't have that count as non-working time as it relates to, overtime calculations.
Seems to make sense anyway, because
People were starting to choose, well, I'm going to schedule my child's medical appointments, non-emergency medical appointments on my, non-on-call weeks, because I'm going to end up on Saturday and have to, now get paid straight time to work on a weekend. And so people were starting to juggle around vacations and medical appointments because of this. And it just got to be where it's like, this doesn't seem reasonable from asking people to requiring people to work.
Distraction is bigger than the bill.
Yeah, I always felt that crediting people for work days on holidays was taking back something that they were given.
So we talked to Lieber Cassidy and said, can we change this? And they said, yes, you can do more. This is your question. So we're going to keep the 40 hours, but we're going to add in the over 8, the over 12.
Change how you get to 40.
Change how you get to 40. It does have a fiscal effect, meaning because
there's a 4th of July holiday and they don't come to work, they're paid for those 8 hours.
right, but it doesn't count as working time. And so then when they work on Saturday, then it,
I agree with what you're doing. It just makes sense.
You're doing the right thing.
This brings me to a question, not intended to occur, but we often have multiple employees that attend these meetings. Do they get it?
yes, they do,
Why?
because they're taking part we made a choice as a district. We can schedule this meeting. This was a board decision years ago. We can schedule these meetings during working hours before 5 o'clock. And then if employees come to these meetings, they get paid for that working time. There was a long discussion about policy, and the discussion was made. We want to make sure that these meetings are available to the most amount of people and employees too, specifically on the personnel committee side. And so we're going to pay them if they attend and they participate in a district event, that they get paid overtime for that time.
So that was a board decision?
That was a board decision. That was a board decision. It goes back many years about
It was back when I was on before I took my vacation, because I think I was the one that pushed it.
You're the one that pushed it.
More than 10 years ago.
because there are other districts that Casitas,
I'm wondering.
Casitas does their board meetings during the day. And so then employees can go to personnel committee meetings, and they're paid because it's during working hours, but it takes them away from the work. And so the decision on our board was, we're not going to take people away from work, but if we're going to talk about personnel issues that may affect them, they should be able to come. They're welcome to come, and we're going
In
to.
any event, it's after hours. They're welcome to come as a member of the public anyway, so it's not.
Right, but so specifically on personnel committees, this was a decision of the board to say we're paying people because we want them here and give them a voice. So the second piece of this sort of overtime is comp time. This is a sort of a different flavor of a discussion. Comp time is where someone works overtime, and instead of getting paid for that time and a half for that hour of overtime, they can bank that hour and a half as a comp time hour and a half. Under our discussions with Lieber Cassidy, there's some concern in the legal world about comp time being a default deferred compensation plan, because you earn an hour and a half of comp time for every hour of overtime you spend, because you get paid that time and a half. And if you then bank those hours in one calendar year and cash them in the next calendar year, you're moving that income to another calendar year. If you bank that time now and you get a pay raise or a COLA or something else, and you cash in that hour and a half, you get paid at the hour and a half at the hourly rate at the time you cash it in. And so you're banking it at $20 an hour and you're cashing it in at $25 an hour. And so there's some concern in the legal world that this is a de facto deferred compensation plan that may not be survive legally long term. Lots of places are doing it. It's private practice, it's public, but Lieber Cassidy felt like there's an issue here. And so it's also a liability for the district because people build up this bank of comp time, and that's a financial obligation that we have to pay those people for those hours.
An AP, yeah.
Because they've earned those hours. They've earned that value. As a compromise in talking with Lieber Cassidy, we came up with sort of a way to sort of put some limits and some policies in place that keep it, but don't have it be so unchecked that it potentially raises legal issues. So what we've included here is that there's a cap of 40 hours maximum that you can accrue, and that it go paid out each calendar year. You can't just let it grow and be hours and hours and hours and hours and go past, new calendar years and new fiscal years and so forth. We're going to pay people whatever their rate is at the time they cash it in. We pay them that rate, even if they earned it at a lower rate. But sort of as a compromise to not have it, we thought that these sets of sort of constraints provided some governance to it rather than being nothing or wide open and uncontrolled balances. So that's what is proposed here.
So what I'm getting to is that they have to cash it in, receive cash, they can't get vacation time.
Right.
Although it does say comp time should be used before vacation time.
Right. So if someone wants to take a day off and they have 8 hours of comp time, our policy would say you use the comp time first. Because the vacation time has been tried and tested legally. It's still got the same flavor of some of the deferred compensation sort of ideas, but it's been tested in the courts enough that, we're not going to change that. And so
You can take it as
you
vacation.
can, but it's still,
Does the vacation time have to be in the same calendar year also?
no, vacation can accrue but in Lieber Cassidy's opinion, sick time and vacation time has been tested enough and it has survived this sort of standard of what it means. Comp time, they think, has some different problems to it because it's sort of a replacement of an hour. It's not like a benefit where you get a vacation day. It's a different color of an overtime hour, whereas vacation is vacation and it's take time off of work. Comp time is really just holding this hour of overtime you earn back here and transferring it forward in a dollar basis. And they think there are some problems with that. It hasn't been adjudicated that it's illegal, but there are some court cases that are starting to look at it in a different light, and they think there's some risk to just having wide open balances without any sort of structure around. That was their thoughts.
So you have to close it out at the end of each calendar year.
Yes. So what we will do is the last pay period that ends in a calendar year, we will zero everybody's back,
Cash out all the comp time.
whatever their hourly rate is at the time. Even if that meant they earned it in January, got a COLA in July, and got cashed out in December, we're just gonna accept that
Reasonably contemporaneous.
reasonably constrained rather than, growing out of control. So that's the essence of this, both the overtime and the compensation time.
Where are we now?
Kind of on the bottom of 58 and into the top of 59 where it talks about,
Can I ask a question about 15.3 on 15?
yeah.
Employee did not permit time for any time missed.
So this is another one of their sort of concerns is if someone says, hey, I'm gonna take off 2 hours and I'll make it up next week. There's a problem with that whole accounting and that whole sort of paid time off. Is the 2 hours really paid time off? Or is it just, next week? And if you work next week and you work those extra 2 hours after an 8-hour day, now you're getting paid overtime because it's after 8 over there and you only had 6 hours here. And so this makeup time, sort of unofficial, is very problematic. Accounting for it, paying for it, tracking it, it's just something that becomes more of a accounting nightmare and a legal liability. And so we would rather say, hey, we're generous on our sick leave and our vacation leave, and since we do have comp time, if you have some overtime hours, you can use those.
The reason I'm interested in that is because my son basically got a concussion, so he was off work a lot. Or he works, you used up all your vacation time, there's no sick leave. So if he needs to go to a doctor or something, he has to go to the doctor. But they allow him to make up the time another day or on a Saturday or a Sunday, but that's their policy, so they're trading the inconvenience of allowing sick leave instead allowing people to make up the time, whereas we're saying, no, you've got sick leave, use that. You don't need to make up the time. In his case, he has to make up the time, so it's
Right.
they require it, so interesting.
It becomes a policy of how you can equally apply it. So it'd be much easier for an office staff to make up time, they can work remotely on a report or something versus collections, cleaning lines on the weekends or in the evenings is going to be very different. So it's hard to equally apply it here as well. And so that's one of the reasons that was in consideration is it's a hard policy to equally apply. And that was one of the recommendations, especially when you have a diverse sort of department format. With very diverse roles, if you can't equally apply it, it can become problematic.
That makes sense.
And then the last item, I think I got everything. Wait, I just saw something. This is page 71, 20-4. It talks about the 10 years uninterrupted and the reference to the salary and benefit schedule.
Okay. And you might put a note back in that previous area and just say, see also section 20.4.1.
That's a good idea.
That would, and I'd know to go look there and I'd understand.
Sure.
And the last item, I think if I caught everything, was on page 104. Basically, just a clarification of standby duty notes.
So I have a question on chapter 23, page 2 on driving. I haven't read this, so maybe pull this apart, but let's just say that an employee is asked to drive 2 or 3 other employees to some sort of a planning meeting or a lunch or whatever that's sponsored by the district, and there's an accident. Who do the injured parties that were in the car sue?
The district's insurance covers the district vehicle.
In their personal vehicle.
If they're in their personal vehicle, they don't carpool. If they're going to a meeting,
They'll be in a district vehicle. So we have any one of the work trucks that are not obviously a huge heavy duty or our district shared vehicle of the van. So we closely monitor any sort of lunch, conference, or work-related event training that they would be going to, that they would carpool. And we require that they take a district vehicle specifically for that reason.
That's good. Where I worked before, they decided that they want to have company cars anymore, so all the employees were responsible for ferrying other employees to meetings and stuff. And some of the employees basically just said, nope, ain't happening. Taking anybody. Anyway, so you guys have a pretty strict policy, it sounds like, around that.
those are the proposed changes. We've got some little text changes that we make based on these, but the proposal would be to take this to the board for adoption unless there's other comments or questions or.
Maybe another 25 words or less on standby. It says the duty begins with all the spaces between normal work hours and Friday.
Right.
Or between the end of shift on Friday, beginning on Monday. And that's fine, but are people getting paid then 62 hours a week? Standby? And they're getting paid that time and a half.
No, we have a standby rate. Don't know the number and
Sorry, minimum of 2 hours, time and a half.
they get a call out.
They get a call out. Okay.
So if the week goes by and they work eight every day and they work their required hours on the weekends that they're scheduled to work, then there's 62 hours of standby time. And that's what is it? $2.25 an hour. So it's sort of the non-working hours pay to just be available on.
Available, yeah. I didn't see that number in here.
It's in our
In the wage salary schedule again, okay. Accordance with the district salary schedule, okay.
Are we setting ourselves up on that? I know there's a lot of other agencies lately that struggled with that. Or just go through something with their on-call.
So
Cedar, somebody's got the same issue as well.
So there's some different agencies do some different standards for on-call. And some have a flat rate per day. Some have a different rate depending on how long you've been at the district. So there's some different flavors of pay. And in talking with Liebert Cassidy, they feel that the hourly rate is the best because to say you've been at a district 10 years and somebody else has been 5 years, so you get paid different and you're providing the same value to the district doesn't make legal sense. And if you're getting paid a flat rate per day, and some days you give the district 15 and a half hours of standby time, and some you may only give 10 because you're on call, but the value of those dollars per hour changes based on some of those circumstances. And they think that there's a problem that comes into different value for different hour for different people. A lot of the things, if you sort of subtly read between the lines here, one of the sorts of areas of law that's changed or sort of matured over some period of time is the value of the employee's expertise given to the district and the district benefiting from that value. And so things are sort of calculated based on value to the district, not based on hours or days or things. And so there's some math involved in sort of coming up with what's the hourly value for that person. And that's where some of this standby time comes into play.
It comes in on that 2 hour minimum on a call out, though. A level 3 operator is going to get paid more on that call out than a level 1.
Sure,
As it should be.
as it should be, but for sitting there doing nothing, and I don't mean doing nothing, but you can be mowing your lawn and you're
Sitting
getting
there
paid to
being available.
being available. And how much is that worth to the district? And is there a rational basis for having different worths to that hour based on how long you've been at the district or how many hours you give during that day? And so there's not an exact science, but under Lieber Cassidy's sort of thought, this is the most straightforward in determining the value of that hour on call. Now, there's some question about how much that should be, but that's a different sort of discussion. But they think that this calculation method where it's turned into a specific hour and a specific value per hour is the most legally defensible.
Difference in value to the district kicks in when that employee is called out, not when they're sitting at home being available.
Right, but if there's, I think it's Goleta has, if you've been with the district 10 years, you get one rate, and if you've been with the district you get a different rate. So you're paying
Standby,
for standby, mowing the lawn. 10-year guy gets $3 an hour, and a 2-year guy gets, $1 an hour. And Lieber Cassidy says that's giving a different value for the same value the district gets, which is to have a person available to answer the phone.
Yeah,
And so that whole per day, per week, I think Thousand Oaks has a per week basis. It makes it easy for an accounting basis. You don't have to count up the hours, because here, every payroll, if somebody's got call outs or something, you got to do the math to come up with 24 hours in a day. And TO says, well, it's just, you're on call this week, you get $300. Well, how many hours did they do on call and overtime and call outs? And Lieber Cassidy thinks there's some deference in that. And so if you read between the lines on lots of this, they're turning things into what's the value the district receives and compensating people for the hours and the value that they provide to the district.
I think they just make it a percentage of the guy's pay.
Well, then you have a guy, higher paid guy gets paid more to mow his lawn than a lower paid guy.
Oh.
Well, in Lieber Cassidy's
The guy
world,
gets made more work than the other guy.
yeah, but in Lieber Cassidy's world is they're both providing the same value. They're both available to answer the phone.
Would say if the reason you have somebody on standby is you'd expect that there could be some type of a problem that comes up. Let's just say that I'm running a nuclear reactor plant. The type of problem that comes up is likely to require the services of somebody that's got 20 years experience to resolve it in some way. It's not likely to involve somebody that has 5 years of experience, even though they may be on standby. So that guy that has the more experience is more valuable to me having there, because he's the one that could actually solve the problem that's likely to come up. However unlikely that is.
Well,
I don't know. It just seems like that's an argument that could go both ways.
in the state's rules, whoever responds has to be able to answer the questions, has to be able to solve the problem. So whether that's an operator 3 or an operator 4 or an operator 5, the state says whoever's on call has to be able to solve the problems. So in their mind, that person, whether they're a 3, a 4, or a 5, is the same regulatory compliance standard.
Regular work day, don't you have people that are of a lower grade that can solve the same problem the person of a higher grade could solve? And it just depends on who your work assignments as to who does the work?
No, they all, you know, are gonna work within their classification and within their expertise. But the on-call time, they're not working, they're mowing their lawn, they're watching football.
I understand that.
It's that, what's the available expertise value to the district? And to have different values, Lieber Cassidy, and I think there's some truth to it.
I can see the argument, but I can see it the other way too. So, anyway, we'll go with theirs.
Are there situations in which you have a person on standby, a problem comes up, and that person decides, or someone else decides, most likely that person, they're called out, say to themselves, this is a problem that's going to require somebody more than me.
Absolutely.
And you call out
They all
another
call,
higher level person.
they call out additional manpower, they call out additional expertise. And so it frequently on call outs, it's one of two things. It's a quick reset something, or it's probably requires more than two hands anyway. And so if there's a spill, there's rarely a spill that one guy can handle. And so if we get a spill after hours and based on sort of the information we get in the phone call about the spill, the guys will probably call, you know, more people before they even get here and see it.
They're organizing themselves to solve the problem.
They know that that line is, if somebody says the spill is in this location, they already know that size line and how full it normally flows and how long it's going to be before that's coming out of manhole. And sometimes people will say on the call out, a lot of times spills come from the fire department because somebody calls and the fire department calls and says, hey, there's a spill and it's bubbling out. Or they say, you know, it's really coming. And so before the first guy even gets here, they've probably called 2 or 3 or 4 extra guys to come in. And so they're going to do that based on their knowledge and expertise of our system and what has been relayed to them. Now, if it's electronic and it comes through SCADA that there's an alarm, frequently they can determine based on the alarm how complicated the problem is going to be too. So if we have a slight power outage and it's something, a breaker needs to be reset, it's one problem. If we get a whole series of different alarms, they know to call a second and a third and the fourth guy. Very rarely, most of our call outs are either minor and handleable by one guy, or and that's or it's the full team kind of thing.
Good that you have a staff you can trust to do it the right way.
Well, today we had a power outage. They instantly go into the mode of knowing what time of day it is, what's the flow in our system, and where they need to go go after the highest problem first. And so they grab the tools and the equipment and the generators and start out into the system to handle what needs to be done.
What was the outage today?
So there's a power outage somewhere over by the lake, and it knocked out Rancho Matilahop pump station, 2 pump stations on Santa Ana, and a couple of meters. The district office lost power for a couple of hours. And so, you know, it took a while for Edison to figure out what it was, fix it. And so during that time, we mobilized generators to the pump stations and then went and checked a couple that had some anomalies in the SCADA system. So the guys went out and touched about 4 or 5 different locations, as well as getting backup power generator hooked up here so the district was running. But that just, you know, in an instant, that just happened and they know where to go. So these are these changes. We'll take them to the board and then go ahead and implement them there, or add changes for the board as a whole to come up with.
I have a speaker card for item 4. Director Stone.
So that's the classification, compensation, and organizational study update.
Wait, we have to go back to item 4. I have Kelly Russell as a speaker card for item 4.
Okay.
Kelly.
Good evening, Personnel Committee. I'm speaking tonight in regards to the proposed employee handbook update. It is concerning some of the proposed changes provide less of a benefit to district employees, as well as in comparison to other local agencies. For example, vacation requests. District proposed change with any vacation requests that are longer than 2 weeks will not be permitted unless approved in advance by both supervisor and the general manager. Casitas Water District, City of Ventura, P and Q units, City of Oxnard, Professional, Technical, and Administrative Support Unit do not have a restriction above supervisory approval or duration. Montecito Sanitary District requires general manager approval for requests longer than 3 weeks. City of Camarillo requires city manager approval for requests longer than 20 working days. Another example is bereavement leave. District's proposed change is eligible employees may take up to 5 days of unpaid protected absence, bereavement upon the death of an immediate family member. Although the district is proposing the employees to take accrued time, other local agencies provide leave with pay. Cedar Mutual Water District, the City of Ventura, G&Q units, City of Oxnard Professional, Technical, and Administrative Support Unit provide 3 days of leave with pay. City of Camarillo provides up to 40 hours of paid leave. Concerns mentioned are not exhaustive. Please consider how the proposed update compares to other local agencies and how the updates will provide support to staff. Thank you for your time, openness, and consideration.
Thanks, Kelly.
So is the primary issue for hours available or pay versus no pay?
Well, let's talk about the vacation time. It's been our practice. I don't recall someone taking over 2 weeks here. So that's how we kind of came up with the 2 weeks. Our perspective, or my perspective on length of time, is as long as it doesn't negatively impact our operational ability. Somebody came to me and said, I'm taking a vacation of a lifetime. I want to go to Europe for 3 or 4 weeks. And we could figure out far enough in advance and accommodated operation. I'd be fine with that. But somebody coming in short notice and saying, I'm taking 4 weeks off, not only can that be an operational issue, it can impact other employees' ability to take time off too. And so we want to be considerate of everybody in terms of granting, excessive or extended vacation off. I mean, we grant the people the vacation. We want them to go take the time to travel, to recharge, to do the things that they want to and explore whatever it is they're, great, fabulous, wonderful. But we wanted to make sure that there was at least some opportunity to say, hey, let's stop and think about this before we just have an open-ended, anytime, all the time kind of thing. We're small.
You've been here for a long time. Have you ever denied somebody's request?
I'm not aware of an over 2 week vacation. We have had some times where, and things get a little tight around the holidays and everybody wants to be off, which is fabulous. And sometimes we have to have conversations with people and say, okay, how do we collectively as a work group
For the measures.
cover the mission and allow everybody to have flexibility, not the first person in who says, I want off, all of this time. So we want to be considerate. The general approach is err on the side of employee time off. Absolutely. But we just wanted a pause to say, hey, where are we? If it's something that you wanted to grant longer time, I understand that. It's fine. Our effort was not to try and limit. We're very generous on our vacation time, but we wanted to be able to have a pause to say, hey, how do we work this out? If if everybody always wants to be off and not on call for, certain periods of time, we have, concerns about that. So most of the time when it's come up, it's like, okay, let's let it happen at the local level. I don't think I've ever said you get it off and you don't. Every time it's come to me or I've heard about an issue, there was some conversations and the people worked it out amongst themselves about who was off and he's going to cover his time for on call and if it can stay at the working group level and they can work it out, that would be fantastic.
Are we allowed to ask her a question?
I think so.
I think that's appropriate.
Your name is Kelly? Okay. So it seemed like within your statement, there were multiple issues. One was the issue of requesting having to have approval for more than 2 weeks. The other was the issue around bereavement at that time.
Very separate issue.
So just focusing on the having to have approval for more than 2 weeks for vacation. Have you personally known a problem like that within the district where somebody wanted it and couldn't get it? In other words, I'm trying to figure out why that came up.
Came from Camarillo, so close to the 4 weeks that you'd have to get city manager approval. I worked there. And then, so when I saw 2 weeks come up, it's like, well, what does everyone else do locally? It seemed that 4 weeks was Camarillo, and then there was that other one that was 3 weeks, and everyone else didn't have restrictions. Travis took vacation, I think in September, and went to England for 2.5 weeks. He's beautiful over for me. So we do work on similar things, but everyone was able to adjust and.
So you say you worked at Camarillo. How many, here's what I was thinking about that when you brought it up is if I'm a company that has a district that has 10 employees, all of them have worked for 20 plus years. They all get a month off, presumably for vacation. And coincidentally, they all happen to want the time between Thanksgiving and Christmas off. So if there's no way to manage that, the district basically has to hire people to come in to work. So I can see
Certified people.
Is what I'm saying. In a small district, it seems to me makes sense that you would have some sort of a policy that would allow, just as Jeff was saying, to balance his workforce so he can keep the place running. I'm suspecting that Camarillo has a much larger staff. So I'm not understand the question because I've taken long periods of vacation off before.
I think the key to the long,
I like the idea. Even then I had to ask, even though the policy was you could just do it, but.
I think the key to longer vacations, and I think they're great. I mean, some people say that the optimum time for vacation sort of regeneration is between 8 and 10 days. But some people have different sort of travel plans or no travel plans. I think one of the keys to the longer time that I would use in looking at that 2 week time is, and we're spending a ton of time on it now, is cross-training people. Is really being able to, we've had an organization that was familial and informal for years, and it worked fabulous. And we had times when if somebody was out and somebody called in and said, hey, what's going on with such and such, we'd say, oh, that person's out, they'll be back next Tuesday. And our customers would say, okay, no problem, I'll call next Tuesday. And it worked wonderfully. All wonderful people. We've now gotten to a situation where some of our obligations on the regulatory side and the customer interface side are much more transactional. People want to wait till somebody gets back next week. They want an answer now. Well, the key to being able to do that is twofold. One is to become more organized and have all that information at the tip of our fingers and have people cross-train. We've had people, Travis was out for 2.5 weeks. We were able to function because some of the expertise of other staff to pitch in and cover things and still provide the required professional oversight that's necessary. We're going to always do it friendly and nicely, but it's become more transactional. People call up, they submit their application electronically, they send an email in and want an answer instantly. If someone's on vacation and that email goes into their inbox, we may not know about it. So all of our applications and customer service come into a common email box so that if somebody's gone, somebody's always checking that box. And I think
Somebody's on call.
so. I think the 2 weeks, and that's just the date we picked. It could be 3 weeks. I'm fine with that. I think we still want to have a pause to be able to say, okay, how are we going to cover that? And how does that interface with our obligations as a district and our obligations as coworkers to help cover each other? You know, if everybody wants off the week between Thanksgiving and Christmas, you know, we can't function completely. We can be a little bit more skeletal than, because things are slow that time of year. And so we can, you know, let a few more people go a few more days, but we still got to have somebody here and the door open. And so really all I wanted to do was say, hey, there's now a line and a pause. And I would look at how do we operate and how do we cross train and how do we help cover each other. So the number of days isn't so important to me as is the sort of the pause, because we're small and we've got places.
Wonder if, it doesn't sound like this comes up hardly ever, but I wonder if the better way, rather than the 2 weeks, 3 weeks, tenured, whatever, if there's something that people take vacation for various reasons. One is vacation. Another is something happens in their family or something, then they have to leave work. They can only use vacation for that. So maybe I'm not inclined to change the language as it is now. I wonder if maybe to resolve the issue where somebody has to go, there's a problem at work with doing that. There may be some criteria established that says you can't deny vacation for certain issues, whatever they might be, but you can have a whole host of maybes, and I don't think that goes.
I am not going to deny anybody. If somebody comes to me and says, I've got a family situation, whatever it is, and I don't need to know the specifics, you know, I'll leave the HIPAA discussions, you know, one-on-one employees with Allison. If somebody comes to me and says, I'm leaving because I have to, the answer is fine, go, we'll cover for you. Because that's absolutely the human thing to do. You know, we're a sewer district, okay? It'll be fine.
It's the advantage of being small, and it's also the disadvantage of being small.
Sure, and the way out of some of those tight spots is to cross train and not have these pockets of information that only reside with one person. You know, when somebody's gone and they're the keeper of all that knowledge on topic A, we're in big trouble. And so being able to cross train so that person goes, hey, I need to take a week off, or I want to take a week off. I want to take 2 weeks off. I'm not going anywhere. I just don't want to be here for a couple of weeks and I want to recharge. Great, fabulous. But we need to have at least some line where we can say, hey, okay, can we work around this a little bit if it's something we can work around? That's it. And so it's not the days, really. That's not the concern.
I'm not sure that I care whether it's 2 weeks or 3. But an argument that appeals to me is the smaller the crew that you have to cover the mission, the more warning management needs when somebody takes off.
Yeah, and we've talked about that with Liebert Cassidy. That's problematic because to sort of put a value on someone's reason for requesting time off and saying,
I'm thinking all requests are the same, but if you're going to be gone for 3 weeks, I need to know a little more in advance to be able to cover 3 weeks than to be able to cover a week or two.
Right. And we're going to rely, and we have a great track record and great employees. We're going to rely on people's professionalism.
That's a responsibility.
To think through that and to be, you know, cognizant of all of us. We're all in this together. And and how do we do something personally that still is thoughtful of those around us in the position we leave them in. Again, if somebody comes and says, I gotta leave right now and I'm not coming back for this because I've got a situation,
Go.
and we'll pull while you're gone. But on the professional side, if you thinking about something, hey, give us an advance notice. Hey, I haven't planned my dates, but I'm thinking about a 2.5, 3 week vacation out somewhere. You know, oh, okay, we can start, you know, being thoughtful about those sorts of things. Again, I've never said no. I know there have been some weeks where multiple people all wanted time off and they got it worked out at the low level on how to share. And there have been days where one guy's on call one day, the next guy's on call the next day, and the third guy's on call the third day in a row because they had to switch around because of people's choice. And I'm going to leave that to them to professionally cover the on call and the time off. And if they can work it out and we're straight amongst themselves, that's fabulous.
Better.
It's better. They trade back and forth the iPad and the trucks and the great.
So
The number of days isn't a deal breaker for us.
At some point, the number of days becomes large enough that you need more notice it coming.
Well, and I'm gonna rely on everybody's working together. We're all in this together and being professional about it. And I'm not even gonna begin to sort of say, well, if you want 2 weeks off, you got to give me 2 months notice. If you want 3 weeks off, you got that just, we're never going there. I can't see going there.
do we need to have a motion or something to keep it? I mean, you brought up a question of.
So that's vacation. If you guys want to change, you can change the number of days now
I'm
or.
not inclined to change what we have written around that. Are you?
I'm not necessarily inclined to change it, but I think it is a point that we should talk about at the full board.
Yeah, I don't have a problem changing it. I think it could be a little bit more liberal, but I think the rest of the board should have
Say.
some weigh in also.
Yeah. And the next thing she brought up was bereavement. We offer time off without pay. It sounds like you're interested in time off with pay. But that's how other districts do it. That's a bigger issue in my mind.
2 days paid and
So the law changed completely, so that is a verbatim from the new law, but, I mean, other than the definitions of qualifying people under bereavement, I believe that you guys can change that to be more generous.
Law says now 5 days
That is
without pay.
Correct, that is verbatim the new law that passed in January. They just literally put exactly what the law actually says. We can't go less than 5 days, but we can be more generous with whether we pay for it. We can't change any of the definitions to the qualifying people. That's legislative also. But I mean, it's definitely
Some
something. we
people
need to talk
qualify for that and some don't.
about. Qualifying people as far as who is considered,
Yeah, you don't get
qualified.
5 days if it's like a cousin.
Okay. Qualifying cause. Yeah, okay.
Well, the question in my mind is not the 5 days, it's the pay.
Yeah, and
Seems to be the biggest issue. Is that right? So I don't know what we want to, that's a full board member discussion too, but I don't know if we want to talk about what we think we ought to do. You know, I could see something along the lines, you know, if my wife dies, well, we might pay to cover that, but if my grandmother dies, maybe we wouldn't pay to cover that. I can see some.
we have that's one of those things that I've touched on a few times here and Allison has too. When you provide different values for different things, there's no legal standard for it. And so we as a board don't really have enough legal standing to say, you know, you get it for first cousins and not for second cousins or whatever the issue is. And they're real sensitive to say you can't assign different values to different things. And so the law says 5 days, no pay. That's what the law says. If you want to do 5 days with pay, totally fine. But you can't say 5 days with pay for this and 7 days for pay with that. And it's, you can go 7 days. You know, you can, however you want to do it, but the value has to be the same.
Got it. Okay.
And if we want to, we want to table that and say, hey, there's some thoughts here. We can present this to the whole board and say the committee was okay with lots of this, but wanted to have a group discussion about this item and this item.
Yeah, I think that's really important to do because I don't want, I personally don't want to have, say I like part of this and then the rest of the committee say they like it and then it gets rubber stamped to the board. We're going to take the time and have the discussions to clean this up. Make it the way we think we need to have it. I think the whole board needs to be on that.
So as I sort of read the items here, one would be the 2-week vacation. One would be paid bereavement leave and the number of days of bereavement leave. One would be to sort of continue and have the full discussion about the overtime and all the different flavors of 40 and 8 and 12 and so forth, as well as the comp time discussion too, about the cap of 40 and the payout per year. And so we'll say, hey, there's a bunch of changes, but let's go talk about item 1, 2, 3, 4, 5 as a board and talk about each of those individual items. That representative.
That's how I would envision it working or what I'd like to see work.
Okay.
That cover your major?
Request for vacation.
Request time, both the two, your major. Didn't leave one out. Okay, good.
That I brought up.
So I think that's going to be a endless discussion with no resolution is what I'm worried about.
No, I think there'll be a resolution. The discussion might take a bit of time, but that's what we're here to do.
Yeah, I'm fine with it. I'm just.
It's going to take the time it's going to take.
Okay. I'm good.
Most of this, and it's hard to tell, there's some of the red line is in red and some of the red line is in blue.
That's different people at Liebert Cassidy making those comments.
Okay,
There's
So,
not ours.
all of the tracked changes are from Lieber Cassidy and they're all per existing state law,
Yes.
which we can decide to liberalize, not to restrict.
Correct. And we can't assign different values to sort of classes of things, days or hours or people or.
Mothers are not worth as much as sisters. Yeah.
Right. We can't do any of that. We can say they're all worth more or they're all higher or so forth, but we can't start splitting hairs.
So one thing we didn't talk about crossed my mind is the issue of employees, male or female, as child. Let's just say it's wife at home and the husband's an employee. Is there some policy around how much time the husband can take off?
Yes, so that's covered in FMLA leave. So there is actually state and federal protections for those sorts of things, as well as leave for other sort of emergent circumstances. There are employee protections in place for medical, bonding, childbirth, paternity leave, et cetera. And that's a whole overarching sort of policy that's referenced here in brief. So it's briefly sort of referenced in here, but that's a much larger animal.
In general terms, there's no distinction between a mother or a father. Mother works here, has a baby, father works here, wife at home has a baby. There is no distinction between the mother, the father, the care for the baby, anything.
So there are basically federal policies that cover that sort of thing. Okay. And we adhere to those. That was my question.
So we'll put together
There are a few
Presentation.
topics that
Yeah, let's put together
we
something.
need to do a little
Take it
more
back so the full board can
discussion.
discuss this.
we'll do the staff report and then we'll highlight specifically items that the committee wanted to highlight for full board discussion. Here are the changes, but A, B, C, D, E, we wanted to have extended conversations.
An individual board member that reads all of the red line and has another question can still ask the question.
Absolutely.
But these are
Wanted to highlight, there's no sort of
the
consensus out of the committee other than we want to talk about these.
Yeah,
five items.
those, you know, we're looking at it and it needs to be updated and that's some of the stuff that we like and this is what we want everybody to look at.
Yeah, okay. Fabulous.
All right. We move on to item 5, classification, compensation, and organizational study update.
So the class study is pretty much complete. They've provided updated job descriptions for all of our classifications. Some of the names change just to make sure that, you know, there's new sort of language and monikers about what someone is called. But by and large, the class study describes a bunch of positions, and to the extent we could, almost every position has sort of a ladder so that there's specific qualifications for each of the steps in the ladder, and each classification has sort of required job skills to be able to move up. And so there's opportunity to grow. We want to grow and mentor our staff as best we can so that they can assume more responsibility. And we've outlined some specific things they need to do to get there. They don't just get there because they spent 10 years. They get there because they know X, Y, and Z and bring that value and that experience to the district. And in return, there's a step up in terms of compensation and authority and responsibility too.
To the extent we fix that, it's going to be better than the 13 years I spent at Rockwell International. That was pretty loosey-goosey. There were grades, salary levels. How you got from one to another was very mysterious.
So the compensation is they are now taking those classifications and they're out looking at the industry as a whole and looking at every one of those and coming up with comparisons between them. It's going well. We'll probably come back to the personnel committee, probably not till the new year with some of those results. But they're doing work and everything from the class side looks good. The other thing we're doing on sort of the overall sort of class and comp study is next Wednesday, we're having an all-staff lunch. We'll talk through all of these changes with everybody. And we're going to talk through where we are with the class and comp study and ask questions and give people an opportunity to ask other questions and see where we are on lots of things. So sort of business as usual in the class and comp study. We'll start having some discussions with staff next week on some lunch stuff, and
We'd be interested to see what the new org chart looks like.
you know, it's when I got here, the way I characterized it, and when it wasn't in a malicious way, it's just sort of the way we were in a familial sort of structure. Was we had a piece of paper that described what Brenda did. It had a piece of paper that described what Ron did and Jim did and everybody did. The classifications for the people that were certified by the state, the collection system and treatment plant, were a little bit more firm but
Legal standards, yeah.
they were sort of describing what people did and not specifically what tasks needed to be done. And so we've converted all of that to now tasks needed to be done. And so people can say, I can do that. I think I want to learn how to do that. Okay, well, the way to get there, if you're here and you want to go there, that would be a great opportunity. Let me teach you, let me mentor you, let me find some training courses, let me find some ways for you to learn those skills to become proficient at those skills. We didn't have that in the old system. So we do now. And so the new org chart is really absent names and more task-based sort of structure. Areas of responsibility, areas of accountability. And so I think it will sort of transcend individual names and individual, sort of ownership of pieces of
And
information.
get rid of a lot of the mystery for people who want to learn, demonstrate skills, and get ahead.
There are lots of great resources to people to learn. We've got some interim people now that are operating and doing well, and they're learning and they're growing and they're asking questions and they're, being able to sort of grow in a controlled environment rather than here, go do it. That never works out well.
I think another important part to this, probably after this study is done, I think that there's going to have to be annual reviews with everybody. Supervisors or whoever is the head of the departments are going to have to sit down with each person and let them know how they're doing. Let them know what they can improve on. Let them know what they don't like. I'm kind of hearing this message from a lot of people that at this time isn't happening. It's really disappointing, I think, because I think that's big for people's growth. They need to know. They need to know if, yeah, you're doing a great job, but maybe this would be an area you want to look at. Then that they know, they can look at that and see.
Okay. If you have more operational standards in writing, you can say to someone, you're performing at this level. This is where you'd like to be. These are the things that you need to learn and demonstrate the skill. You'll be better off. We'll be better off because you have the skill.
I often think that sometimes we take for granted that everybody knows as management what's being thought of them, and it's not always that way. And
I think though, one of the problems happen is you do all those instructional videos or whatever and prove this and prove that. There's an expectation though that the employee gets to advance. Typically in salary, that's what they're most worried about.
What?
So, a small group, you can only advance so far regardless of what you know, and that's it. Because we already have somebody doing that at the job. So you kind of, in some way, have to do what you're suggesting, but also manage the expectation that just because you do that doesn't mean you're going to get, a promotion to the next grade because somebody's already there. And that's just something I would worry about. I don't know what you.
Well,
but
we had some positions where we didn't have a ladder. Well, we will now in almost every position. We had people that they did this and there was no job description for the next step up or the next step down. And I don't say step down in terms of promoting someone. I say if that person leaves and we recruit for a position, we only have the one job description to say, do this.
This is what Joe did, yeah.
If we have a ladder and somebody comes along and they're really good, but they're just not ready to do this set of level of expertise, but they're this or even this and they can grow. Now we have job descriptions and qualifications to say we can take this person from the outside who doesn't match that, but matches this and has opportunity to grow. We didn't have that before. We had a whole bunch of single shot sort of job descriptions. And so we didn't have room for people to grow because we didn't have a job description or a title or a salary ladder or anything for them to grow into. It was, you do this and you do it well and you've been doing it well for 5, 10, 15, 30, 40 years, but it's still only this. We didn't have any room to say you can do this. It's really hard in a government place to say you're going to do more, but that's not what your job description says you're going to do. And if you're going to ask somebody to do more or they do more, or the expectation is that they're more accountable and responsible for more, then you got to have a job description and pay them for more. You can't have them existing up here and pay them down here. And so it's really problematic when you only have this. People, and that's why we went to this. We went to say, If you're here, you got 2 spots. If you're here, you got 1 spot. But because we're small, we're not going to have a 4th, 5th, and 6th spot up here. We have limitations because of our size, of our complexity, of our structure and our ability. But at least we got this now with the new system. And I'd love it if everybody got up to the top, because that means there's this broader, deeper skill set. It still limits people who are at the top to say, I don't have anything more. Maybe we can survive with that. But when you have a whole bunch of onesie twosies in these little silos, in these little pockets of information, it's very hard to say, how do I get ahead? Well, your job description says you're doing everything you're supposed to do. And I don't have anything that says you can, if you do 5 more things, I can compensate you, even if it'd be great as a district if you did those 5 more things better. I don't have a place to put you. And you can't do this in a government. In the private side, you can go, you're doing awesome. We're going to give you another 10%. You're doing even better, another 10%. We can't do that here. We have to have a specific title, specific qualifications, specific knowledge and experience you need to grow into. There are other departments in other cities where you can take, like the engineering world, and you can start as a assistant engineer and have 5, 6, 8, 10 steps and spend your entire career at that organization. And every 3 years, you get a promotion to a new spot. And by the time you retire, you haven't run out of spots. We don't have that. And so we have some problems being small. We have some benefits of being small. And so we try to work through that in this new organizational chart, and these job descriptions intended to say, this is as broad and as deep as we can make it for our organization and given where we are and what we are. But there's still limitations, because if you start at 2 and you go to 3, there's not a 4, 5, 6. We're gonna try. We're gonna say these represent all these job description and ladders represent the obligations that the district needs to comply with, and it gives us some room to grow for people to assume more responsibility and learn and grow. It's not unlimited in its ability and time. So I think it's better. I don't think it's definitely not the way some big agencies are structured, but that's a function of we have 21 authorized positions. We don't have 40 or 50. Now, even with 21 positions, there's a lot of people that have got a foot and a finger in 5 or 6 pies, because we don't just have 21 things to do. So it's a balance. It's how do we provide opportunity and help people grow and learn, and at the same time acknowledge what we are and how big we are and our limitations.
And that's what sold me on the whole idea of doing this study, that got into the details of what we're trying to do. It made more sense to me. Because first impression of this is, yeah, it's another study. We're going to put on the shelf. We're going to spend $100,000 and we're not going to do anything with it. But that isn't what you were proposing.
We're already using it. We're already, it's not done, and we're already using it because we've got some vacancies, and we're starting to craft, these positions and these expertise that we're going to go recruit for in this new ladder.
I thought that was a good justification for it.
Anything else? We beat that one to death. So committee members. Committee, general manager.
Nothing.
Okay, with that, we'll stand adjourned at 6:44.
Hi, guys.
Kelly,
And do I need to shut it down here?
I heard you.